Welcome. I'm immigration attorney Andres Mejer. Welcome to my weekly live show Para Ser Legal. Today, I'm going over the public charge rule in detail. Let me start by saying this rule will change immigration as we know it. If your dream is to become a green card holder, it just got a whole lot harder.
Calificas para ser legal, quieres saber, solo llama al abogado Andres Mejer.
A few months ago, I did a Facebook Live where I talked about how immigration, USCIS, that's U.S. Citizen Immigration Services, wanted to change public charge policy and how it would be applied. If you look below, we're going to post the link right there. At the time, many states filed suit to stop these changes. Well, the Supreme Court decided last week that they would deny the preliminary injunction. They decided that USCIS could implement its change while the lawsuit continues. What does this mean for you as you move through your immigration journey? It means in every state but Illinois, February 24, 2020, the rules of the road have changed. And they've changed dramatically. So anybody that files after February 24, 2020, they will have to deal with these new rules. Now, what are those new rules? Well, I can tell you what the rules are, but the forms themselves are changing. How much are they changing? We don't know. We haven't seen the forms yet. So we're talking about Form I-129, that's like fiancé visas, religious visas. I-485, that's for green card. I-539, that's for change of status, for non-immigrant visas or to extend status. I-864, which is affidavit of support. It usually goes along with any green card applications. And these changes will be presented to us by February 4th. That means we're going to have less than 3 weeks, that's about 20 days, to figure out how to apply them. This affects the entire country, but the state of Illinois, which still has an injunction. Now, why does this matter to you? Well, one, it is a pocketbook issue. If you have an attorney, your fees are going up. After this date, you will be paying more for your attorney. That certainly will be true for us. It'll likely be true for every other attorney. Why? There's an additional form, I-944, which is gonna be applied. It is massive, 20 pages. It even asks for your credit score. It asks for everything. It is very detailed. But again, we haven't seen the final form, so it's hard to say. So who does this affect? This rule is all about admissibility. So this applies to people applying for admission to the United States. That means if you're filing for your green card, doesn't matter whether you're filing in the U.S. or outside of the U.S., that's an admission. Now, if you're a green card holder and you're traveling outside of the United States and you want to come back in, hey, you're going to have to deal with this rule. If you're a non-immigrant visa holder and you're requesting an extension of your visa or a change to another visa, think student visa or tourist that wants to become a student visa, or an H-1B, or vice versa. Now, who doesn't this apply for? Who's exempt? Asylum refugees, TPS, T&U visas, VAWA, special immigrant juvenile, and special country-specific applications like Iraqi or Afghanistan. Now, public charge inadmissibility does not apply to citizenship. If you're applying to become a U.S. citizen, you don't need to worry about this rule. You don't need to worry about DACA, medical deferred action, or TPS. Those are just not relevant to this ground of inadmissibility. Now, what is the definition of public charge today? So I'm going to tell you what it is today, and I'm going to tell you what it's going to be after February 24th. So today, and let me tell you, in 15 years that I've been practicing law, I can't recall one example where I've ever seen a client of mine be denied their green card because they're inadmissible because of the public charge. So up until they might say that the affidavit of support is insufficient. You need to show more income, but they don't couch it in terms of public charge. That's obviously going to change. So today, the definition is likely to become primarily dependent on the government for subsistence. Wow. What does that mean? if I'm the government, and obviously I don't work for the government and I don't represent the government, I'm a private attorney. But if I'm the government and you immigrant want to come into my country, I want to make sure that you're going to be self-dependent, self-sufficient. I don't want to let you in and then have to support you. So you need to show me that you're going to be self-sufficient. That sounds great, except what if your criteria is so challenging that you're denying people because they may become dependent on the government for some reason under some circumstances. Where should that line be drawn? Well, today it's been drawn very far to denying people. So after February 24th, 2020, the definition of who will become a public charge is anybody who receives one or more public benefits for more than 12 months in the aggregate within any 36-month period, such that if you receive 2 benefits in 1 month, it counts as 2 months. So let's just say that next week, I don't know, I lose my job, I lose my house, something bad happens, and I apply for public assistance. The government helps me with housing, it helps me with food stamps, it helps me with insurance. So every one of those benefits I receive counts as a month, even though I only received it for 1 month. Now that's a big deal because in the past, I would need to have benefits for 12 months straight. But if I get 3 benefits in 1 month and I have it for 4 months, that's still counted as 12 months. So that's a pretty big deal. Now, keep in mind, most applying for a green card don't qualify for federal assistance, even if they want it. But many may still apply for state aid. You need to be very careful as to what you're applying for. Now, how is this rule applied? So this is the totality of the circumstances approach. So the 12 months out of the 36 is a relatively simple process to calculate. What benefits did you get? Add them up. Is it more than 12 or isn't? That's easy. But the bigger problem is the ability this new rule gives an officer to determine if someone in the future is likely to become a public charge. So, you received some benefits, less than 12. Okay, you're not inadmissible. But the government can look at that and under all the circumstances say, hey, you're likely to need some help in the future. And for that reason, I'm going to deny you. So this test will consider the totality of the circumstances. That means no one factor alone should be dispositive. But think about it. This is not objective. This is subjective. Objective is 12 out of 36. It's clear. It's obvious. It's interpretable. Now, when you're telling me may, what does that mean? Under what guidelines is the officer going to have to apply this rule? We don't know. What are they going to look at? Well, we know the factors. One is age. If the applicant is under 18 or over 61, that is a negative thing. Health. Now, health might affect employment, school, or immigrants' ability to provide for themselves or their family. A health issue that needs extensive medical treatment, that's a problem. Let's say you come down with cancer, God forbid. Future medical expenses. Well, you have asthma and you may need to be hospitalized in the future for it. It requires continuing care. Private medical insurance that would cover the necessary treatment, well, that obviates the problem of having a medical condition. Household. How many dependents do immigrants have? Listen, if you come from a religious family, and I don't care if you're Catholic, evangelical, Muslim, or Jewish, chances are you come from a large family. That means your income has to be a whole lot higher. What are your income and assets? The focus on income should be more significant than the public charge makes seem. Now, for an affidavit of support, the petitioner needs to show that their income is they can maintain the immigrant at 125% over the poverty guidelines. I don't think that's enough anymore. You're really going to have to be at 200 or 250% depending on what other factors. So does the immigrant have enough assets to pay for reasonably foreseeable medical expenses? What happens if you're asthmatic? This is not stuff the government was focused on before. Now it is. But that's not enough. They also want to look at liabilities like mortgage, credit card debt, unpaid child support. They're looking at everything. What's your education and skills? What's your length of employment? You're authorized to work, but you're unemployed. That's a negative factor. Frequency of job changes. How long have you been at this job? How often do you go from one job to the other? What's your level? What's your English proficiency? What's your level of education? Now, caregivers are exempt from this. They don't have this criteria at all. But listen, they're looking at everything. Remember, Trump wanted a merit-based immigration system. That is in essence what they're doing here, but they're doing it without Congress's approval. They're doing it unilaterally. So, applying the new rules. 3 steps. Step 1, you got to figure out whether the public charge even applies. So we're looking at who. What's the category of immigration status that the immigrant has, and what are they applying for? So what do they have today, and what are they applying to? So let's give some examples. Roberto, he's 68 years old man from El Salvador. He has TPS. He's been in the U.S. over 30 years. He's working, and he's never received any benefits whatsoever. Now, Roberto has medical problems, including sleep apnea, COPD, diabetes, high blood pressure, and lower back pain. Roberto had, matter of fact, his medical condition was so bad he had to reduce his work hours because of his health, and he only earned $14,000 last year. It's enough to pay his rent and utilities, but it's barely over the poverty guidelines. Now, Roberto's daughter just became a U.S. citizen, and she wants to help her father become a lawful permanent resident. So, applying the public charge rule, step 1. The rule applies because although Roberto has TPS, and he's exempt from that for TPS, he's applying for his green card. Now, for the green card application, the public charge rule does apply. Now, where? Remember, which rules are we going by? USCIS or Department of State? He can get his green card in the U.S. if he lives in certain states because getting TPS is considered lawful admission to the United States. Not New Jersey, but if he's in the 6th Circuit, which means Kentucky, Michigan, Ohio, or Tennessee, or in the 9th Circuit, which is Alaska, Arizona, California, Guam, or Hawaii, any of those states, just by having TPS, daughter can apply for him, and in about a year, he can become a lawful permanent resident. But in New Jersey, he will need to have entered legally through some other admission. So either he applies for advanced parole, and he can still do it, although it's obviously harder because Trump is trying to get rid of TPS, or someone applied for him under 245I before April 30, 2001. Otherwise, he needs to travel outside the United States, and he may need a waiver because he was likely in the U.S. for more than 1 year without permission before getting TPS. If he has to consular process, he needs insurance, number 1. And his medical conditions becomes a big deal unless he's insured. Number 2, if he needs a waiver, he doesn't qualify for a waiver. His daughter is applying for him. He needs a spouse or a parent who's a U.S. citizen or lawful permanent resident and show how they're going to suffer extreme hardship. So he's going to have a real problem if he needs to travel outside the United States. He may just be better off filing it as if it was an adjustment, as if TPS was a legal entry, and litigate. Fight with the government saying, listen, what you're doing is not right. The 3rd Circuit, which includes New Jersey, Pennsylvania, and Delaware, should be the same as the 6th or the 9th Circuit. And chances are he'll win, but who knows? Litigation is what it is, and it's hard to predict the outcome. Now, he has a better chance if he can adjust to the U.S. rather than consular process because he won't need to worry about a waiver and he won't need to worry about insurance. But TPS has medical conditions, never received a benefit, but low income, and has medical conditions. That's a problem, particularly in the consular process stage. Now, secondly, where are they applying? In the U.S., the rules are USCIS. Outside the U.S., it's Department of State. There are differences, but Department of State is updating their rules in conformance with USCIS. We just haven't seen them yet. Let's talk about Eddie. He's a 29-year-old graduate student. He teaches to pay for tuition since he isn't eligible for any student loans. Now, Eddie was born in Mexico and has DACA. He came to the United States as a kid. Eddie married a U.S. citizen, Irma, last year, and they have an 8-year-old U.S. citizen daughter with minor learning disabilities and mild anxiety. Now, Irma works as a teaching assistant. She earns about $30,000 per year. Eddie's daughter receives Medicaid, and his wife has medical insurance. Irma receives treatment for severe asthma, and just last year, she had to be rushed to the emergency room for an asthma attack because she couldn't breathe. So let's apply the public charge test. 1. Who's being affected by this? We're talking about Eddie. Eddie has DACA. DACA doesn't have to worry about the public charge rule. But what is he applying for? Green card. Okay, green card is subject to the public charge rule, and for that reason, we have to continue with our analysis. Now, where? What do I mean by where? Again, what rule is being applied? Is it in the United States? That is adjustment of status? Or is it outside the United States through consular process? If he consular processes, he will need a waiver. Based on these facts, he can show extreme hardship to his U.S. citizen wife. Because she has a medical condition, there's financial issues, and they have a child also with a medical condition. As a single mom, it's going to be very difficult for her without Eddie. Now, he will still need proof of medical insurance if he's going to consular process, but since Irma is insured through work, well, she should be able to add Eddie, since Eddie is a DACA holder, has work authorization, and has a social. So it shouldn't be difficult to include him. Although Eddie didn't himself get any benefits, the fact that his daughter receives Medicaid is relevant because it is public assistance. It doesn't disqualify him on its own, but the government may consider him as possibly need public assistance in the future. So they're going to need a joint sponsor because they're low income. Also, the government could use Irma's asthma to find that she likely will not be able to support Eddie in case she has a condition. So again, we'll need a joint sponsor. But Eddie likely will be able, with a good attorney, Eddie would likely become a green card holder. It'll just be harder in a variety of circumstances. Step 3, what are the positive and negative factors? Karina is a lawful permanent resident for the past 12 years. Her son is a U.S. citizen, and he applied for her. Now, she's 72 years old and recently retired from a job as a cashier. Now, Karina receives Medicare and Medicaid, but no government benefits, no financial benefits. Now, Karina's sister recently became ill, and she wants to travel back to India for a few months. Karina's worried that if she leaves, she won't be able to come back to the United States to be with her son and grandchildren. So let's apply the public charge test to her. Who? Karina is a lawful permanent resident. She's not subject to the public charge as long as she re-enters the United States within 180 days. If she stays more than 180 days, she's now applying for admission again, and now she's subject to the public charge rule. Step 2, where? Well, she's outside the United States coming back in, so that's consular process. She needs to worry about the rules of the Department of State. And how? Now, the public charge is principally focused on cash assistance or long-term care. She has insurance, and she hasn't received any cash assistance, so she shouldn't be found to be a public charge. Unless circumstances change, she will likely be able to come back in. Thank you very much for listening to us. My name is Andres Mejer. I'm an immigration attorney, and again, anybody that wants to apply for their green card must do so as quickly as possible before this new rule goes into effect, because it will be a lot harder. It remains to be seen how it's going to be applied. What it really means is you need to be able to make a really good and compelling story. For the same reason that all our waiver cases, I can't think of it. We've only had one denial in the past 5 years in probably close to 100 petitions. Why is that? Because we're good at telling stories, and we're also, your story in particular, and we're good at figuring out what's your circumstances. Listen, here's what you need to do in order to be able to apply, and we work with you to do that. This is going to be the same thing. Public charge is something they're going to use to deny you. So you need to be overly cautious in how you apply. And you need to start making changes, like getting insurance, increasing your income, or getting a joint sponsor. To be able, you don't want to find out once you're outside the United States that you're being denied because you're a public charge. Please subscribe to our channel and share this video with your friends, because this rule is game changing, and I don't mean that in a positive way.